Zoom control panel, you'll see one of those little drop downs should say Q&A. If you don't see where it says Q&A, go over, depending on what your computer shows, where it says the little circle that says more with 3 dots in the middle of it. If you click on that, it should show Q&A in there if you don't see it already on the standard Zoom control panel. Once you've opened up the Q&A window, you can disconnect it or undock it, they say, and pull it off the Zoom presentation into its own window if you want. So here's what we'll do one by one together. Number 1 says the acronym RESPA stands for the Real Estate What Act. What do you believe the S and P in the acronym RESPA stand for? Type it in to the question and answer portal there. Real Estate What Act? Yep, Settlement Procedures Act. The Real Estate Settlement Procedures Act is what we're looking there for number 1. Number 2, the 2 disclosures we mentioned earlier required under RESPA, the loan estimate, the LE, and the blank disclosure, we said we'll talk about in more detail later today under TRID, the TILA RESPA Integrated Disclosure Rule, created the loan estimate and the blank disclosure. Do you recall what is the blank disclosure? Good. Yeah, excellent. Yeah, the blank disclosure is the closing disclosure. We said the loan estimate is like the price tag on the deal, while the closing disclosure is the receipt, and we'll talk more about those later this afternoon. Finally, here, number 3, disclosure of the affiliated business arrangement must be made immediately upon what? What's the timing requirement for the ABA? When is it due to the consumer? Good. Yeah, it is due immediately upon referral. Remember earlier today we said it's often given within 3 business days of application. That's what's typical, but the law does not require it be given unless it's actually necessary at the time of referral of an affiliated company. That's the distinction I made earlier, and it's one that's important as you prepare for this exam that you can see. Let's jump into ECOA, the Equal Credit Opportunity Act. The next of the 4 major laws that you see on that outlined section of the federal law portion is the Equal Credit Opportunity Act. And we'll start here, the same place we started with RESPA. And what I mean is, make sure you memorize the full name of the law, the Equal Credit Opportunity Act, before memorizing or trying to memorize its acronym. Remember, the danger I said is when you memorize acronyms only, before long you're left with a bowl filled with alphabet soup and you've got no idea what any of it means. If instead you memorize the full names of the law, the acronym takes care of itself. And the name of the law does tell you what the law does. Equal Credit Opportunity Act is an act, a law, that requires equal opportunity be given to anyone that applies for credit. Now, I want to be clear here. It does not mean that anyone that applies is given credit. It means that anyone that applies for credit should be treated similarly to anyone else who is similarly situated. In other words, if you are equally qualified to someone else, you should both be offered very similar terms. That's what the Equal Credit Opportunity Act requires. Now, how does it protect the consumer? We said the trick to this test is not only just memorizing what is the Equal Credit Opportunity Act, but understanding its application. How does the Equal Credit Opportunity Act protect the consumer? Well, it was intended to eliminate discriminatory treatment of credit applicants. Bottom of that page on 15 in the book, or 17 in the book rather, 15 in the PDF, it says, this was primarily the reason that ECOA was enacted, through evidence that women were being treated unfairly or not on an equal basis to men when applying for credit. It was initially a gender discrimination law, and in the days that ECOA was rolled out, there were scenarios where a female might have applied for credit and been told, listen, we're worried about your childbearing age. We're worried that while you may be qualified for this loan now, it's likely based on your age that you're going to leave the workplace and begin to raise a family, and you may not be as eligible 2 years, 3 years down the road. Believe it or not, in those days, you had creditors that might have even asked a female applicant for documentation from their doctor about family planning. You might have even had creditors in those days requiring a female applicant to have a co-signer sign on their loan, even though they might have been perfectly qualified on their own. And the lawmakers stepped in and they said, no, you can't decide what she may or may not do in the future. If she's qualified, she's qualified. Offer terms relative to the loan she qualifies for today. You can't assume what she may or may not do. And then they expanded it from gender discrimination to promote the availability of credit to all credit-worthy applicants. You see where it says, regardless of race, color, religion, national origin, sex, marital status, age. In plain terms, they basically say it doesn't matter what you look like, what you sound like, where you came from, what you believe in. What matters is, are you able to document your ability to repay the loan? And if you are, let's make you an offer according to your documentation, according to your qualification, and that's it. I always tell people, you imagine the Equal Credit Opportunity Act to being kind of like that scenario where you've got a partition between the loan originator and the applicant, and all you can really see is like the shadow on the partition, like the old school dating game back in the day. I know I'm a little older guy here, but you can't really tell who's on the other side. And really what that forces the loan originator to do is just pay attention to the loan documents themselves. Make the decision based on the facts, not based on personal characteristics. ECOA also addresses redlining and reverse redlining. Redlining occurs when creditors refuse to make loans based in certain neighborhoods because of assumptions about the applicants that may live there. A lot of that driven from personal characteristics. Assumptions creditors may make, well, if they're applying from this zip code or that town or that set of blocks or that city, they're not going to qualify anyway, so why would we bother even offering services there? Well, that's highly discriminatory. How would you know if someone's eligible or not if you didn't allow them to apply and then treat them according to the strength of their application? Redlining is blatantly discriminatory. Reverse redlining is the literal opposite, really. Where instead of turning people away because of assumptions they won't qualify, in fact, it's targeting a lot of those same borrowers with plans of saddling that borrower with more onerous loan terms. More onerous meaning more expensive, more dangerous, more likely to lead to bad outcome, taking advantage of the vulnerable. And reverse redlining really was a staple of what was known as the subprime lending industry of the mid to late 90s, early to mid 2000s, and what many would point toward as the reason of the mortgage meltdown era of 2008, 9, and 10. What landed us in the environment we are today, where we've got to have people take and pass an exam, we've got to have people licensed, etc., because there wasn't a lot of oversight for those working in our industry prior to that. You had people being taken advantage of by people looking to make a quick buck. Now, the regulatory agency we mentioned a little earlier under RESPA that you will see over and over again today, mention of the CFPB. Here we go again, top of the page on 18 in your book, 16 in your PDF. The Consumer Financial Protection Bureau is the primary regulator here, and you see that ECOA is implementing regulations are collectively known as Regulation B. Highlight that as well. Just like I said, it's important that you recognize Reg X as RESPA and vice versa. RESPA is Reg X. Same concept here with ECOA. It's important you recognize Reg B and ECOA are interchangeable. And I recommend you write it down as something like B equal as a way of remembering ECOA and Reg B are one and the same. You may not see a question that says, what regulation letter is ECOA? Reg B. But you very well may see Reg B mentioned, even if it's as a throwaway answer to a question that's got nothing to do with the Equal Credit Opportunity Act. No, it's ECOA. Loans that are covered by ECOA, the next one here in the middle of that same page, really there is no limitation. ECOA covers any extension of credit. Whether it's business, commercial, agricultural, residential. To be clear, guys, ECOA, the Equal Credit Opportunity Act, is not a mortgage law per se. It's not limited to just the mortgage transaction. It is a law that covers any extension of credit. Of course, it's a mortgage law because that's all we do is extend credit. But know that its application is not limited to our industry. You see defined terms here, much like you saw within RESPA. I would say that anytime you see these terms, it should attach themselves to ECOA. In other words, when you see adverse action, you should be in your brain thinking, oh, this is an ECOA question. This is an ECOA term. Adverse action means you're turning someone away. It's a creditor's refusal to offer credit or offer credit in the terms that were requested. In the mortgage world, usually it's, I'm sorry, we can't do your loan. Adverse action. Discriminate means you're using a prohibited basis, like someone's specific characteristics, ethnicity, sex, etc., as the basis of treating someone less favorably. You're using personal characteristics as the reason to either turn someone away or offer lesser terms. Elderly is defined as being the age of 62 or older. Now, when we talk about age discrimination, it is normally perpetuated against the elderly. Normally, you've got creditors that may make it more difficult for an older borrower to qualify, may stack the documentation list that they're required to provide to make it more difficult, to the extent that the older borrower might just give up because they don't want to go on such a long paper chase. Because listen, creditors understand that they can't just outright say, Mr. Jones, you know you're 67 years old, right? You really think a 30-year loan's a good idea? You know, in other words, they're communicating to Mr. Jones, I don't think you're going to live that long, sir. Maybe you should take a shorter loan. That's illegal. Because if Mr. Jones at 67 is able to disclose or able to document income in an amount sufficient enough to qualify, we can't turn Mr. Jones down. But instead of being that blatant, that deliberate, a creditor might instead require Mr. Jones bring a handful more documents. Or they may scrutinize a little harder retirement income, pension income, and make it more difficult for them to document that support of the information to the point where the older borrower might just say, well, I guess I don't qualify. And you'll see in a handful of pages that's equally illegal. And that's usually where you see age discrimination happen, where older borrowers are made to think it's more difficult because the lender doesn't want to do the loan, but they don't come out and say it directly. You see marital status defined as the state of being unmarried, married, or separated. Those three categories alone unmarried, married, or separated are the only three categories allowed to be identified on a credit application, mortgage or otherwise. Credit cards, car loans, student loan, mortgage loan. And in a mortgage scenario, it's not because you become better or worse qualified based on marital status. But specifically in a mortgage scenario, you might have another person that has eligibility or access to the line of credit or to the credit overall because of the marriage. You might have someone else, again, based on the marital status, that's got ownership stake of the property that's being used as collateral. And whether they're on the loan or not, because they own the collateral jointly with the spouse, that loan does affect them. And you'll see this tomorrow as we get into chapter 3 and we take a closer look at the application itself. You'll see where this comes up under borrower information in section 1, and you'll see the subcategories that roll up to things like unmarried, that include single, divorced, widowed. But these are the only three categories, unmarried, married, and separated, in the aggregate, the high level, that are allowed to be identified. Then you see prohibited basis. These are lists of what's called protected characteristics. Race, color, religion, national origin, sex, marital status, age. These are areas, again, where we are not allowed to look at a borrower's personal characteristics as detail as to whether they qualify for the loan. Doesn't matter. We're looking at the borrower's ability to repay the loan. Those protected characteristics are considered prohibited reasons or basis to either turn a loan down or to offer less favorable terms. You see notice of action toward the bottom of that page. These, are disclosures required through the Equal Credit Opportunity Act, and these are what we would call status disclosure. And I would tell you this, in terms of test taking, any question that you see referencing loan status or application status, anytime you see the word status, it's a dead giveaway that they're talking about ECOA. Status will always equal ECOA. It'll be an identifier that this is an ECOA question, and status is always required, as you see, within 30 days of receipt of a credit application. Make sure you notice that it says credit application. It doesn't specifically reference mortgage. Because in the mortgage world, we often act much sooner than 30 days. We said under RESPA last hour that there are certain disclosures due within 3 business days of application. And that's pretty much the standard in the mortgage business when we take an application from a borrower to whom we can offer a loan, that we would send them their initial disclosure sets within 3 business days of the application being taken. Now, ECOA, because it's not specifically a mortgage law, has a general timeline here that says within 30 days of taking an application, the borrower or the applicant has the right to know of the status of their application. Meaning, am I eligible or not? If the creditor takes adverse action, the notice must provide a statement of the reasons for the unfavorable decision. In other words, I'm sorry, Mr. Jones, we can't do your loan, and here's why we can't do your loan. That's expected within 30 days. In the mortgage world, is it likely we're going to have that happen much sooner? Yes. Most of the time, within 3 business days of application. But no, when we're talking about credit applications in general and the status of a credit application, and you might even see test questions that say, according to ECOA, if a borrower is being turned down for a loan, within what time frame must their status application, their status disclosure be sent? Within 30 days. Within 30 days. Know this distinction with the Equal Credit Opportunity Act because it is a general law about every type of credit. This timing is very general as well, within 30 days. In the mortgage world, we often act more swiftly than 30 days. but know the difference. If it's an incomplete application, you go to the top of the next page. It says if that application is missing information, we're required to let that applicant know what's missing. I'm sorry, Mr. Jones, we cannot make a decision on your application yet because we're missing X, Y, and Z. If you provide to us X, Y, and Z within a reasonable amount of time, we'll continue your application further. And reasonable amount of time generally means once we've made the borrower aware that we're missing X, Y, and Z, we would restart the 30-day clock for them to submit what's missing to us. Bottom line is we're saying, look, we need additional information to really thoroughly evaluate your application. We don't have all this information, so we'll wait a reasonable time, another 30 days. If they don't provide it within that 30-day window, at that point, normally what happens is an adverse action would be given. I'm sorry, Mr. Jones, because you didn't respond to us within a reasonable amount of time. We're still missing information. We're going to turn down your loan because of the information we haven't received. Think about it this way again. If you're a consumer applying for credit, don't you think you have a right to know, did you get the credit or not? That's all this says. If you've applied for credit, you have a right to know yes, no, or maybe, meaning incomplete, within 30 days. Now, to be clear once more, in the mortgage world, we often act much sooner than 30 days. In fact, as we talked about under RESPA, if we've taken someone's application and determined we are able to offer them a loan, RESPA requires we disclose our offer within 3 business days. That's easily within the 30-day window of ECOA, right? So particularly when we're able to offer someone a loan, we are required to offer within 3 business days. Now, you see valuation disclosures. Hang on one second here. Give me a thumbs up if you can hear me still. I just switched microphones because my little headset is telling me that the battery charge is not what it needs to be. So I'm going to put this on the charger, and you may hear a little bit of an echo just because I switched the microphone, but that'll give this charger time to pop that thing back on. I should have put it on the charger during the breaks, but I didn't. So valuation disclosures, middle of that page in 20, it mentions here that if there's a transaction involving a mortgage loan, the consumer's got the right to be made aware that if we have to have an appraisal done, they're going to get a copy of that appraisal. If we have to have an appraisal done, Mr. Jones, don't worry, you'll get a copy of it. And that initial disclosure is due within 3 business days of them applying for credit, of them applying for a loan. Doesn't mean the appraisal's got to be done within 3 business days, but they must be made aware that once the appraisal's completed, they'll get a copy of it. The initial disclosure goes out with the initial disclosure package within 3 business days of application. Once the appraisal is completed, though, the second part of this requirement kicks in. Once the appraisal is completed, a copy of that appraisal must be provided to the consumer promptly or at least 3 business days prior to closing, whichever comes first. The point of this is, think, as a borrower, if you're buying a home, and let's say you've agreed to pay $500,000 to purchase that home, you have a right to see what is really the official document indicating the value of that property. Don't you think you'd want to know? I agree to pay $500,000. The appraiser thinks it's worth $520,000. I got a good deal. You have a right to know that. And so the lawmakers have tweaked the rule a little bit here to say, yeah, don't worry about having to request a copy of it. You're going to get a copy of it at least 3 business days prior to closing your loan, which means it gives you a few days to review it to make sure if you've got any questions about the condition or value of that property, you can get those satisfied prior to closing the loan. Now, listen, for my brand new people on the call here this week, this may seem obvious to you. Of course I want a copy of my appraisal, and I agree. But it's not always been the case. Years ago in this industry, the rule used to be this. If your lender did not give you a copy of that appraisal, you had to submit a written request within 90 days of closing the loan to have a right to receive a copy of that appraisal. That's the way the rule used to be given, or used to be written. Now here's the thing, most mortgage companies over time have done the right thing anyway. In other words, they've given copies of that appraisal anyway, because it was the right thing to do. But some companies, like the one I worked with the first almost 2 years of my mortgage career, they didn't really make appraisals available to the clients because there was some benefit if that appraisal came back at a higher value than anticipated. There was some benefit to the lender in making sure the consumer wasn't aware, because they could reconfigure the loan in such a way that might have made the lender more money. And that was the nature of the game in some cases for subprime lenders in those days, which is when the lawmakers stepped in and they said, oh my goodness, mortgage people, if you're not going to do the right thing on your own, we're going to have to change the law that requires you to do the right thing. Which is now why the law says the borrower gets a copy of their appraisal promptly, or at least 3 business days prior to closing the loan, whichever comes first, without the borrower even having to ask for a copy of it. And this is a pattern you're going to see throughout the remainder of the day today, and several times again throughout the week. A lot of these changes in law that we've fallen under in the last 12 to 15 years come directly from the inadequacies of our industry doing right by clients. Then you see disclosures regarding monitoring programs. That's the middle of the page on 21 in your book, 19 in your PDF. And this monitoring program they're discussing here is HMDA, the Home Mortgage Disclosure Act. The Home Mortgage Disclosure Act is a monitoring tool that the CFPB, the Consumer Financial Protection Bureau, uses to make sure that companies are compliant with the Equal Credit Opportunity Act. Let me explain this way. The Equal Credit Opportunity Act is more or less a honor system law. What I mean is, the regulators have said to credit companies, whether mortgage or credit cards or car loan companies, they've said, look, ABC Mortgage, you know what discrimination is. Don't do it. And make sure you've written your policies and procedures in such a way that prohibit discriminatory treatment from occurring. Don't do it. But the regulators understand, they can say, don't do it, but people are still going to do it. So the regulators have built a monitoring structure in place through the Home Mortgage Disclosure Act that requires reporting of mortgage application data, generally on a quarterly basis, from most companies. So that even though they expect the mortgage company is not discriminating based on their policies and procedures being written right, they're going to verify it by looking at the application data they've taken. And HMDA, the Home Mortgage Disclosure Act, is one of the laws later in the back of this section in the chapter related to law that are lumped into a grouping called others. In this section of the test outline, you'll see there are 4 major laws: RESPA, ECOA, TILA, and TRID. And then there are 10 others lumped together in the same category. HMDA is one of those others, and we will talk about it later today. But together with those other laws, as it supports the major laws we're spending a lot of time in.
8111 stand for.
Okay, that takes us over to record retention. Under the Equal Credit Opportunity Act, there is a requirement that records be kept for at least 25 months after notifying an applicant of action taken. In other words, this is also part of documenting our taking the application and the disposition or status of that application. If ever there were creditors or regulators to come forward to say, hey, we've got a complaint from the Petersons. They said that you didn't treat them right. Can you show us documentation of your interactions here? Record retention expectations are 25 months in this case. Now, what's specifically prohibited under ECOA? Middle of the next page there, 22 in your book, 20 in your PDF. This is actually pretty straightforward. Based on what we've already defined through the Equal Credit Opportunity Act, overt discrimination is where there's blatant refusal to offer credit based on their personal characteristics. They've given you ethnicity and religion here as examples, but any personal characteristics being used as the reason to turn someone down or treat them less favorably is overt discrimination. Redlining is an example of that, refusing to offer credit in particular neighborhoods due to the race or ethnicity of the residents that may live there, right? Based on the assumptions about the people who live there and their inability to qualify. How would you know if you didn't give them a chance to apply? You see disparate treatment shown here when a creditor treats a loan applicant who's a member of a protected class differently than other loan applicants who are similarly situated. That's called disparate treatment. I tell people to think of the word disparate in this context to be like different, but with a negative outcome. You've got two applicants who are equally qualified. One's been given favorable terms, and one's been given less favorable terms or turned down flatly. That's disparate treatment, and that's illegal as well. Remember, the whole point of the Equal Credit Opportunity Act is we're considering people's eligibility only on their loan applications, not based on their personal characteristics. Disparate impact is when a creditor treats a loan, adopts a neutral policy, rather, without discriminatory intent, without reason or means to discriminate, but in fact, the policy does discriminate. They give an example here of a lender that may have a policy internally that they don't want to do loans for anything less than $250,000. And while they might assume, hey, listen, we're not trying to discriminate against any particular applicant, we just don't want to do low loan amounts. What they may not realize in instituting that policy is that they may have illegally affected certain demographics or certain markets that they're able to serve and disqualified people without even realizing that they've disqualified. This is one of the reasons that companies have got to be very careful about their policies and procedures as they write them in the terms of the loans they want to make, and means tests, not just look at the first or third or fifth step, but they've got to practice those out 10, 12, 15 steps down the road to make sure there aren't any unintended consequences from their policies that they've not thought through. That's disparate impact, an impact that does lead to discrimination even though it was unintended. Prohibited inquiries, top of the next section there, talks about inquiries about a person's personal characteristics other than those used for HMDA data collection as being prohibited in terms of credit qualification. We can't ask about a borrower's race, ethnicity, sex, and use the answers to determine credit eligibility. We've said it is prohibited to consider someone's personal characteristics as a means of loan eligibility. And beyond what's collected from a demographic standpoint for government monitoring, none of it can be used to determine loan eligibility. You see discouragement. ECOA prohibits creditors from making oral or written statements that might discourage someone from applying. Instead, ECOA says you should encourage people. Your advertising, your marketing should encourage people to apply. Not discourage, not turn them away. Then you see requiring a cosigner. It mentions here the creditors are prohibited from requiring the signature of an applicant's spouse or any other person if they're not a joint applicant, assuming the individual that is applying qualifies on their own. This takes us back to the beginnings of ECOA. And one of the first ideas here that female applicants were being treated differently than male applicants because of the creditor's assumption that she may leave the workplace at some point to raise a family. It says if that applicant is qualified on their own, you cannot require that they have a co-signer. But I want to make sure we're clear here because people sometimes read that and think, well, that means we can't get a co-signer? No, that's not what it said. If you want to use a co-signer to improve your application, if you need to use a co-signer to improve your application, by all means, you can use a co-signer. It's not illegal to use a co-signer.
Bà có thể có còn.
It just says, if you're qualified on your own, the creditor cannot require that you use a co-signer alongside. And then you see other prohibited practices at the bottom of that same section. It says a lot of the things that you might already anticipate. You can't refuse to consider public assistance as income. If someone's income is derived in part or in whole through, let's say, Social Security or disability, as long as we've got the appropriate documentation of that income and that income is made in an amount sufficient to qualify, then it's legit income. It's income that we are required to consider. We can't turn it away because we don't prefer its source. You can't assume a woman of childbearing age is going to stop working to raise children. I know, again, when you say something like that out loud today, people go, what did he just say? But this was the reason ECOA was created, because primarily female applicants were being treated less favorably. Creditors were discriminating because of their assumptions. Top of the next section, it says you can't refuse to consider income from a pension, an annuity, or retirement benefit. We alluded to a few minutes back that elderly borrowers are oftentimes kind of indirectly discriminated against. They're not necessarily told, no, I'm sorry, Mr. Jones, you're too old to qualify because we think you're not going to outlive the terms of the contract. That's blatantly illegal. That's blatantly illegal. No, what oftentimes happens is creditors may make the documentation requirements a little steeper for an elderly borrower, which would then often lead to them deciding, I guess I don't qualify, and giving up. The last of these says you can't refuse to consider regular alimony or child support. In other words, if the borrower's got alimony income or child support income that is properly documented, that's what they mean by regular. And properly documented means A, it's got to be court ordered, divorce decree, separation agreement, something that's a court order, and B, it's got to be paid as court ordered. We have to have proof that it's being paid as court ordered. And if both are true, we cannot refuse to consider that income as qualifying income. It does say parenthetically right behind that the borrower is not required to show alimony or child support income unless they want to use it or need to use it as qualifying income. We don't have to ask about it. They don't need to show it. Someone's saying, did he just say government assistance doesn't count as income? No. I said, if they've got proper documentation of that government assistance income, Social Security, disability income, and that income is made in an amount sufficient to qualify for the loan, it cannot be turned down. It cannot be turned down. People sometimes assume if someone's on disability and that's the only source of their income, then they're not qualified. Just because disability income, people assume it's lesser income. It's not true.
as long as it's documented, and as long as we have the proof of it, and it's income made in an amount sufficient enough to qualify, it's sufficient income. It's documented income. Okay? That takes us now over into what is one of the more unique areas of the Equal Credit Opportunity Act. And we said this is kind of like an honor system rule. I mentioned this a few minutes back. We said ECOA kind of says, look, ABC Mortgage, you know what discrimination is. Don't do it. We expect you to write your policies and procedures in such a way that would prevent you from discriminating against applicants. And part of that requirement, that self-policing structure here, is also the idea of self-testing. It mentions ECOA encourages creditors to conduct self-tests to identify potential violations of the law. So in addition to writing your policies and procedures, ABC Mortgage, make sure you're auditing your loan applications, your loan files, your loan originators, your systems, and test that they're not resulting in discrimination. Oftentimes, testers are used, secret shoppers, if you will, in pairs, where individuals will pose as loan applicants and evaluate the company's treatment of members of a protected class. And some of you on the call have been around as long or longer than me. You've probably been on the other end of some of these applications or these phone calls. I know for sure over the course of some years, I've had some phone calls or applicants. I hang up and then 8 minutes later I get another one and like, wow, those were eerily similar applications. Huh. That was weird. And that might have been people in your company from the compliance department calling and testing. Sometimes companies will hire a third-party company to do the same. And they'll secret shop. And what they'll do is keep record of all of this, because when the regulators come to do their audits, when they come through to do their audits, they're going to look to see what testing mechanisms has the company got set up. What have they done? When did they last test? When did they last do the secret shop? And the expectation is this: when you're secret shopping, when you're testing or self-testing your policies and procedures, the regulators say, listen, ABC Mortgage, as long as you're doing this testing, if you've identified a likelihood that discrimination may be going on, more likely than not, that's the burden of proof, they say. If it's more likely than not discrimination is going on, you're expected to take corrective action, meaning adjust your policies, tighten your policies, change your procedures to make sure consumers are better protected. And if you're doing that, if you're taking corrective action on your own and it's deemed to be worthy, it's deemed to be helpful, then you don't need to report it to the CFPB. Kind of like, test your systems for problems, and if you identify problems may exist and you continue to tighten and tweak and improve, then you don't need us to come sniff around. It's kind of like what I tell my sons. If I hear a ruckus in the other room, as my dad used to say, I don't know if you guys have ever promised yourself when growing up, I will never say what my parents said to me and my dad. I'll never speak like that to my kids. And then years down the road, you hear something come out of your mouth as a dad or a mom, and you're like, what did I just say? Was that my dad's voice I just heard? I never ever thought that I would say to my boys or any of my kids, don't you make me come in there. I don't know if any of you have ever heard that one, but I got that all the time when I was a kid. I was the youngest of three boys, and my middle brother and I would always fight each other, and my dad would say that to us all the time. And now I find myself instinctually, without even realizing I say it, when I hear a boom in the other room or something come crashing down, boys, there you go. Don't you make me come in there. And what that means, if you've never heard it, what it means is, I know whatever you're doing in the other room, you shouldn't be doing, and so do you. So fix it before I've got to come in and fix it. Because if I've got to come in and fix it, neither of you will win. Neither of you will be happy with my solution. You'll be better off figuring it out between the two of you And I tell you that story because that's essentially what the CFPB is telling creditors. Don't you make us come in there. You know what discrimination is, don't do it. And if you believe you've got an issue, fix it before we have to, because if we've got to fix it, you're not going to like the way we do. Because penalties for violating the Equal Credit Opportunity Act can include certainly actual damages, meaning whatever harm's been done is to be made whole. But it can also include punitive damages, which means make an example of that company, make it hurt. Punitive damages can include up to $10,000 fines for individual actions that led to or stemmed from discrimination, and as much as $500,000 or 1% net worth, whichever's less, in class action lawsuits. Class action lawsuits are when there are many consumers that have been harmed, and there's a law firm that found out, and they invite those consumers that have been harmed to join together as a group because there's power in numbers, right? You're not going to sue the company yourself. We're going to sue on behalf of you and 50 other people. And in a class action lawsuit, what usually happens is the company will just cut a big fat check that all of the members of the class will split along with the law firm. Right? In other words, if the class action settlement is $500,000, the law firm gets $300,000 of it, and the members of the class split the other $200,000. So each member of the class gets a check for $18.14, and the law firm gets $300,000. You know the class action deal is, right? Sometimes it's a little more rewarding for the class action members, but that's the point of it. Is there's power in numbers, and the law firm takes a big chunk in that sense. But they do limit it from there as well. The point is, guys, the CFPB says, listen, there's a lot of creditors out there, not just mortgage, but credit cards, car loans, student loans. Remember, ECOLA covers all of it. The CFPB says we don't want to get involved in all of this. Please try to do the best you can to fix it yourselves, to monitor it yourselves. You'd prefer we're not involved, because if we've got to get involved, we're going to be angry, and we're going to really penalize you. And it also mentions here right at the bottom of the page that there is a statute of limitations. You want to highlight where it says the statute of limitations for individual claims of discriminatory treatment is 5 years. In other words, if you feel as though you've been discriminated against, you'd better file your claim within 5 years or forever hold your peace. Outside of 5 years, it's expired. Now that takes us over to the third of the four major laws. And just what do I mean by major law? If I take you over to this NMLS test content outline here, as we get into our top of the hour break, we've covered RESPA already. We've just wrapped up the review of the Equal Credit Opportunity Act, and now we're moving into the third of these four major laws, and this is the Truth in Lending Act. We'll talk about that when we return 10 minutes from now.